I'm going to, I think that they have given you a copy of my PowerPoint, and to the extent that I can completely confuse you, I'm going to zip through most of it as quickly as I can and get to the part that I think is most relevant to all of you, which are the examples, which I hope we can maybe have a little bit of fun with, but I also think will illustrate some of the things that I've described as complicators in these sort of circumstances, as well as to maybe give you a little bit of insight into at least this judge's thought process relative to custodial changes. I submit to you that most judges, when they come to these kind of decisions, struggle with them because they care about making the right decision. And as often as not, these decisions are much closer than what you would like to think they would be. So let me give you just a real quick background on me. I'm a district judge in the 12th Judicial District. I cover the I cover the 12th Judicial District, the Southern Swing, Banner County, Kimball County, Cheyenne County, Dual County, Garden County. About 33 to 50% of my caseload involves domestic relations or divorce-type work. Prior to that, I was a county attorney here in Scottsbluff County for about 3 years. Had a steady caseload of both abuse, neglect, and delinquency juvenile cases. Prior to that, I was in private practice for a few years doing domestic relations and juvenile advocacy. So, the case that was referred to me as a talking point, if you will, for my conversation with you today is this one, In Re Interest of Ethan M. This was where my wife started snoozing, because she said, look, you're not going to be talking to a bunch of lawyers, the lawyers in the room notwithstanding, you're going to be talking to normal people who wouldn't know what the deuce you're talking about when you say 18 Neb App 63. The lawyers know what I'm talking about. My encouragement to all of you, if you're interested, is to read this case. I certainly think it impacts and has had an impact on the manner by which juvenile judges, county judges acting as juvenile judges approach these kind of cases. As I say here, it seems to be causing much heartburn or maybe some mild indigestion. No one is entirely sure, but it seems to be causing some issues. And my submission to you and the premise that I'm going to start with today is I don't think it is as confusing or as troubling as it might appear at first blush. I think what the Court of Appeals was saying, and there's a lot of things they were saying in re interest of Ethan M., but I think the principal point they were trying to make in that case was, if you're going to act like a district judge, you got to follow the rules that a district judge follows. I don't think there's more to it than that. I'm wildly oversimplifying it. But I think that's a general premise behind the holding. There's some statutes I think you have to be considering when you're dealing with these kind of things. And I'm not going to go over those in any great detail with you, except to say this. This statute, if you folks are intending to dance this lovely dance of custody modification, you have to know this statute. You have to. It's the Nebraska Parenting Act. I think it is a critical change in the way that domestic relations law is administered in this state. There are new requirements that you're dealing with. A requirement that a parenting plan has to be attached to every decree and every order. You have to set forth and make certain findings. You have to require mediation. There is no more, the standard old-style language was fair and reasonable, right, Judge Warden? It was always, Dad gets fair and reasonable and liberal visitation. Well, what the deuce does that mean, right? Because certainly what's fair, reasonable, and liberal to me may be very different than what's fair, liberal, and reasonable to Ms. Elliott. Right? So there were fights. It wasn't clear. So part of what they were trying to do here, and that's a case that said that, Court of Appeals, Supreme Court have said no more of that. You have to be specific. There's new language, there's new procedures. You've got to complete parenting classes before you can get divorced. You've got to complete the directives of the Parenting Act. it applies to new cases that are filed, and it applies to old cases that existed prior to this change in the law, but are coming back up for modification. One of the most interesting linguistic changes is you don't refer to it anymore as visitation. It's called parenting time. And judges still trip up on that. I've been working on this for a couple of years and I still trip up on it. Because you think of it as visitation, but that's not what it is anymore. It's not visitation, it's parenting time. There's some differences between juvenile court and district court. I'm not going to go over with you in great detail. You can see them in the PowerPoint. This one I think is one of the most interesting differences, because I'm not certain how many of you that don't know, because you would have no reason to know, but how many of you have gone to a juvenile court case and thought that the clown car had just emptied every lawyer in town into your courtroom that day? Right? Who are your participants? You've got the state. The county attorney's office is there. The Department of Health and Human Services is there. Now they're good friends with Boys and Girls Home are there. You're going to have family support workers and supervisors and case supervisors and case management supervisors and supervisors, and you're going to have the parents and the parents' attorneys and the parents' guardian ad litem sometimes, so you might even have 2 lawyers for mom or dad in there. God help us all. You've got a guardian ad litem for the kid, you've got the foster parents, you've got CASA, you've got Speak Out, you've got whoever else can think to say, I want to have a part of this particular proceeding. And they all wander in. And they all look at Judge Warden and say, please, sir, I want to be heard. That's right. And we've all learned the universal sign. This is... I always assumed it meant wrap it up and I'm not done with you.
And when you get this,
and in fairness to you, Judge, I'm waiting for you to do that with me today. So at some point when you've had enough of me, I expect I'll be looking, and you just go ahead and give it and get at it, and I'll know it's okay. Shut up, because he's done. Now then, go to a standard divorce case. Who do I have in my courtroom for a divorce case? I've got mom, I've got dad, and maybe I've got 2 attorneys. Maybe. As often as not anymore, I have 1 attorney, and with greater frequency, I have no attorneys coming in. I've just got mom, I've just got dad. Because they can't afford attorneys or they don't want to hire attorneys. And that's fine, they don't have to have attorneys to come to court. But I don't have to deal with and sort out all of this stuff. I sort out these folks, and sometimes these folks. You can have a guardian ad litem in a divorce case, but mom pays for it, or dad pays for it. The state doesn't pay for it. I don't have the authority to order a guardian ad litem. This is the part where Michelle, my wife, said, you cannot possibly show people that. So I'm going to skip it. Then she said, this isn't any better, so I'm going to skip that too. My point is, let me get to the point on the flow chart. You start an action with a complaint, you serve it on somebody, the other person then files an answer and a counterclaim, and that tells the judge what everybody's fighting about. That's as simple as I can make civil procedure. Ralph Whitten is now rolling over at the University of Creighton Law School saying that I've managed to reduce 2 semesters of civil procedure to 30 seconds. A poor 30 seconds, mind you. So my point here is that when we're talking about modification of custody orders, which is what was happening in re interest of Ethan M., you have to understand how you got there. And how you get there is you have the initial complaint or petition to establish paternity, child custody, parenting time, and support, or a decree or a petition to divorce, a petition for a dissolution of marriage action. and you get through the process and you come down to either a final order establishing paternity, support, parenting time, or a decree of dissolution establishing those things, and theoretically that order in the initial proceedings lives forever. Theoretically, that order is designed to tell everybody what the rules are that they're to live by as it relates to one another and as it relates to their kids until that child or children reaches the age of 19. And then life happens, right? People move. Kids get older. Things happen in life that require a review or a modification or require at least an examination of whether a modification of the order is in order. And the modification procedures are the same generally as the initial outset. Somebody complains. They file a complaint. They file a petition. They file a motion in the open court case, the paternity case, the divorce case, and they say to the judge, there's a problem. What you did before doesn't work now because whatever. That document gets served on the other party. And I'm going to say at this point, whoever that might be, and I'm going to encourage you to think back to differences between district court and county court, because I have some questions as it relates to this about who gets served at this point in a county court proceeding. We'll get to that in a minute. So they get served, the opposing party files an answer and a counterclaim, and it comes down to the judge, either by way of a settlement or it gets set for a trial. At the end of that, then there's a new order. And that order stays in effect. Again, it is theoretically living forever until the kid turns 19. Or until somebody comes back in and says, wait a minute, you completely screwed it up the last time. It's got to go this way because of this reason or the other. So how do you do that? What are you trying to prove, or what are you obligated to prove in order to get a modification? Something has to be different from the last time the order was changed or modified. That becomes important here in a minute. It has to be a material and substantial change of circumstances, something that had the court, had I known about at the time I entered the initial order or the most recent order, would have or could have likely changed my decision relative to the custody of the kids. This is the part that I like the best because it keeps the lawyers to their point. Things that happened prior to the last modification, irrelevant. He was a dirtbag loser who always cheated on me right up until we got divorced, and then I divorced his sorry keister and I found myself a better person. That's lovely. That's all good things that you could have told me at the divorce. 3 years later, it doesn't make a bit of difference to me. If you wanted me to consider that, you needed to bring that to my attention initially. Well, she's running around, or she used to run around all the time. She was always in the bar on Friday night. She was drunk every Friday night, and she was drunk every Saturday, and now you're wanting to give her kids on Friday and Saturday. How's she been doing since the last time we were in court? Well, I haven't seen her in the bar for 2 years. Don't care. I don't care. Talk to me about it at the time. That's the point. So your questions, what's changed and why is it important? We'll get to that here in a minute. If you believe something sufficient has changed, you file your complaint, you allege your material and substantial change of circumstances, and I think you have to identify with some specificity the material and substantial change of circumstances. It's not enough just to file a pleading that says, Judge, I want custody of my kids because there's been a material and substantial change of circumstances, hugs and kisses, defendant. Now go serve it on the plaintiff. The plaintiff has the right to know what it is they're being accused of doing. So here's my question. In the county court proceeding that we're talking about here, where somebody has decided that the best way to handle these things is to come to the county judge and say, I'd like to change custody, who files that complaint? I think the parents clearly have the right to do that, right? I mean, they clearly have the right to do that because they'd have the right to do that in my court. Does the county attorney's office have the right to do that? State of Nebraska, they're a party to the juvenile action, right? They're a party. Do we want our county attorneys? How many county attorneys do I have in the room? I got at least one. We want our county attorneys to be filing those things? Custody changes? I don't know. Maybe we do. Guardian ad litem. Got a lot of guardians ad litem in the room. Great lawyers. Great lawyers. Lawyers that are champions for the children that they work with. Lawyers I was privileged to work with as a guardian ad litem, and lawyers that I am privileged to see come before me in practice. You guys want to be filing these things? Mr. Strecker is here on behalf of the Public Defender's Office. Bernie, do you want to get your fellows trained up on domestic law? No. In addition to the post-conviction relief stuff that they've got to be responsible for, and making sure that they know the right law to educate the judges on as relative to your motions to suppress, do you want those guys to be working domestic relations? I don't know. Maybe. I don't know. Here's where I got confused when I was reading In Re Interest of Ethan M. It's dicta, which to the lawyers in the room, they know what I'm talking about. To the rest of you, it means nothing. But here's my confusion, the language that confused me. Moving party, whether it was the state or, I think her name was Brenda, it doesn't matter. I put in mom, it was mom. Moving party, whether it was the state or mom. Holy cannoli. Does that mean the state can move? I don't know. I don't know. It certainly suggests it to me, and I got questions about that. Do your county attorneys know about domestic relations law? Maybe they do. In rural Nebraska, we probably have a little better shot at that because, you know, for example, Mr. Pierce is here. He's got a private practice. In addition to being the county attorney for Garden County, maybe he knows something about domestic relations law. To me, it also raises the question about what services are to be provided through the county attorney's office or the public defender's office in these counties where we've got that. We got the steps. So here's my question. When you're filing a motion to modify, who gets served? In my court, the only person that gets served is the opposing party, who is either dad or mom. You've got at least one other party to a juvenile action. You've got the state of Nebraska. Do you have to serve the state of Nebraska on that? I think you probably do. But if you do, then what rights does the state have? What happens if the county attorney looks at your motion and says, holy crap, I don't want mom to have the kid? I don't know. Do you serve the guardian ad litem too? Guardian ad litem can move the court, right? In any juvenile action, if the guardian ad litem, I used to love that. Guardian ad litem has a lot of power in a juvenile action. Do you serve the GAL because they're, I don't know, are they a party? Sort of, maybe, I don't know. Responsive pleadings and cross claims. Mr. Strecker and his staff are going to have to start boning up on, do I cross-claim at this point to get custody of this kid with my client who clearly doesn't want his ex-girlfriend to have the kids? Discovery. Judge Warden, do you really want to be duking it out with your with counsel who may or may not know about the rules of discovery relative to civil proceedings, about what information they have to give to one another in a typical domestic relations case? I don't know. Discovery issue or that discovery issue, then you get to this lovely last part, the setting of trial. All right, so we're going to have a trial in this case. Average custody trial for me is a half a day. Most are a day. At least 30 or 40 days in your calendar a year that you could set aside for custody trial, right? Mr. Mickey, I know Judge Mickey, he's new to the bench, so he's got all the time in the world. It's not like he's learning anything or anything. Okay. Burden of proof is on the moving party. They have to show that there's a material and substantial change of circumstances, and that it's in the best interest and that it is in the best interest of the child to change custody. So it's a two-step process. You have to show the material and substantial change of circumstances, but that's not enough. In addition to that, you have to show that the removal or the change of custody would be in the best interest of the child or parental unfitness, which leads to another question that I have relative to county court proceedings. In a typical abuse or neglect or dependency type case, haven't there already been a judicial finding that some parent or another is unfit? So do you have to prove the second step or not? I think you do, but I don't, is that res judicata? Is it collaterally estopped? Are you, anyway. Oh, here we go. These are my favorites. All right, let's talk about some examples. And I want you, as we're talking about these examples, this is a little bit of audience participation, because by now, unless my frenetic wandering has kept your attention, because it's clearly not the information I'm giving you, at this point we're going to do a little bit of audience participation. So I want you to think about the way we're going to proceed with these examples like an inverted pyramid. We're going to start with the real clear ones, and we're going to move down to what I think the premise that I'm trying to drive home with you is, and that is that these custody cases are not nearly as clear-cut as most attorneys wish they were, because the clear-cut cases are the easy ones. And those are the ones that settle long before they get to the courtroom. That most of these cases are exceptionally fact-dependent. So, let me ask you this. Mr. Strecker, do you think that it is a material and substantial change of circumstances that the ex-girlfriend has moved in with a new boyfriend? Probably not. Probably not. What if I tell you, Ms. Elliott, that the new boyfriend that the ex-girlfriend that the mom has moved in with is Ted Bundy's slightly deranged, more deranged half-brother? You think that's enough to change custody?
It's better than the tax you gave Mr. Strecker, but I don't think it's enough yet.
Well, maybe it's not, but we're getting closer, right?
Yeah.
We're getting closer, at least. So you've got, and these are, I would submit to you that these are typical concerns that parents have. They get divorced, they separate from one another, if they're boyfriend, girlfriend, whatever the new language is that you use in that regard. And they're quite content to have gone off and found greener pastures to play in. But God help them if the ex-girlfriend or ex-boyfriend, their baby's daddy or baby's mama, goes off and does the same thing. Well, I don't have any trouble if she has the kids, but by God, I don't want that dirtbag loser that she's living with to be around him at all. I would submit to you, kind sir, that were you to ask her how she feels about your new girlfriend, that perhaps, just spitballing here, but perhaps we might find some common ground, that you aren't very happy with her new boyfriend any more so than she is happy with your new girlfriend. Okay. Is it enough? I don't know. Sometimes it could be, sometimes it's not. This is one of the most terrifying, god-awful, sweet niblets, please don't say it to me moments for any judge. I am a devout whatever. And my dirtbag loser ex-husband wants to take my kids to his church, which ain't my church. And the kids are going to hell. Those are the moments right where you go, Governor Heinemann, I really appreciate the appointment. I am finished. This has been a hoot and a half, but I am out. Right? Who on earth am I? Who am I to insert myself into the middle of the religious upbringing or lack thereof, and that always is the big one. Well, he never wanted to go to church with us when we were together, and now that we're apart, I don't care. He can have all the parenting time or visitation or whatever you people call it these days that you want to give him. But by God, on Sunday morning, that kid's going to be in church with me. Now, I'm going to bring that kid up right. And you, judge, you're going to have that happen. Not me. No way. I'm touching that thing with a 10-foot pole. Because who am I to get in the middle of the religious upbringing of a child? But it's always an issue. And then I'll add that last one. It's a little clearer that you shouldn't get in the middle of it, right? When it's, I'm a devout Christian and he doesn't go to church. That's the simple one. That's up to the two of you to sort that out. What if I add this fact? That Daddy now attends the Jim Jones branch of the Cults R Us. Well, then we might have a ball game, right? Then we might have something to talk about, but I guarantee you that it's going to be a touchy subject for any judge to get involved in. And most of us are going to run screaming. Here's another good one. At least I think they're good. See, this is the best part about being the speaker. You might think these are god-awful examples. I think they're interesting. And you're stuck with me for at least another 30 minutes. 20 minutes maybe. I don't know. I don't have... And Judge Warden isn't yet. Okay. So here's my question. If these are the allegations, it's a material and substantial change of circumstances because my ex-husband, the dirtbag loser that he is, just got a recent DUI. Is that enough to change custody? That alone? I don't think so. Probably not. I'll add this fact. Does it change anyone's opinion about whether it is or it isn't if I tell you that he got that DUI with both kids in the back seat of the car? I'm going to submit to you that it certainly makes it a point to discuss. Whether it's enough or not, I don't know. But at least you've got a ball game there, right? All right. So let's get to some of the examples that I think might be a little more near and dear to the hearts of juvenile lawyers everywhere. Mom has a history of methamphetamine use. And in the initial outset, let's just say that Mom, and we don't know anything yet about Dad at this point. We've got Dad and we've got Mom, and Mom is the one who presents herself to the judge with the history of methamphetamine use. But that history are two convictions, a year ago and 6 years ago. Who gets custody of those kids? Under just those facts. What's your gut reaction? Dad. Right. That's right. I'm not trying to trick you. I'm setting these up for a reason. Now I'm going to add this fact. Now we find out that Dad met Mom while they were shooting up together. Does that change your opinion? Probably. Because in the initial outset, it looks like Dad's living a clean life and Mom's the one that's got the trouble. Now you're thinking to yourself, maybe Mom's just the unlucky one who's been caught a couple of times. And Dad's been skating and he's just been fortunate not to get clipped. What if I then add to the facts that one of the two kids was conceived at a time during which the two parents were using together? Because how many of these relationships are temporary? They get together for a while, then they're apart for a while. Then they get back together for a while, and then they're apart for a while. You're narrowing it down, right? And it becomes much, much more fact-dependent. Now I'll add that Mom just got arrested for possession of methamphetamines. Pen barrel with a little white substance on the end of it. So now what do you know? Or at least what do you suspect? Right? Mom's using again. What happens if and so it becomes more clear that maybe Dad should have the kids. Kids were around at the time, it becomes even more clear that maybe Dad's the right one to have the kids. But then I add that last fact. Dad's on probation at this very moment for a hot test, or with a recent hot test. So, judges, who gets custody of those kids? Let me ask you it this way. Who in this room is sleeping well tonight, flipping the coin in their head about which place to put those kids? Not too very many of us, right? So when you see the judges with gray hair, you got a better idea. Here's another one. Dad's a convicted batterer. Not alleged. I purposely use the word convicted. He's not alleged to be a wife beater. He is a proven, convicted beater of women. Who gets the kids, in your mind, just intuitively? Who should have the kids? On just that fact. You don't know anything about mom at this point. Mom. Now, mom is the chronic alcoholic with a series of short-term boyfriends. Anyone want to make that call? That's not a question that comes before me.
That's in my head.
This is another one. How many times in a juvenile case, we know who mom is, right? Because mom was a parent, had baby, makes her mom. That's pretty straightforward. Pick a reason why mom has been found to be unfit. And again, I use those words carefully. Judge Warden has made the specific finding of fact that mom is unfit. I don't care why. Pick a reason why mom is unfit. Who in your mind gets in your head just intuitively should get custody? Dad. Now I tell you, Dad's never been around. Sorry, Grandma. And you want to talk about heartbreaking cases, bring me back to discuss with you grandparent visitation rights in the state of Nebraska. Dad has never been around. Does that change your opinion of who should get the kids? Sure it does. Has to. Now I'll say, okay, Dad's never been around. Instead of Dad's never been around, Dad's been mostly absent. He comes around when it's convenient. Every 6, 8 weeks, maybe once a year, twice a year, sends them a card, maybe at Christmas, maybe remembers them on their birthday. Are you feeling better about giving Dad custody? Not a whole lot better, I wouldn't think. What about if he's sometimes around? Yeah, he shows up at the occasional softball game in the summer, if he remembers the softball game in the summer, and he showed up to parent-teacher conferences once 2 years ago, and he's a little bit diligent about being a dad, but not particularly. Are you still feeling comfortable? Are these cases sounding at all familiar to you who dance around in juvenile court? This one was the one that drove my wife crazy. And for those of you who don't know, my wife is a pediatric physical therapist. She actually, I think, is subpoenaed into court this afternoon, ironically enough, to testify. She works with kids a lot. Mom has been found to be unfit, but she is diligently working. And again, I use the word diligently purposefully. She is diligently working on her rehab program and her case plan. Dad is unknown and not locatable. They've tried everything, but including running the ad in the paper saying, if you want to claim the kid, ... We don't know who Dad is and have no way of knowing where he is or who he is. And you've got great foster parents. I mean, in your head, I want you to think of these foster parents as ma and pa kettle with the big farm that the kid can go play on all day long. They love these kids. They think these kids are the greatest gift they've ever been given. They love the kids. They cherish them. They put them in great clothes and they take them to every school function, and they're incredibly involved foster parents, and they would like nothing more than to adopt the child. Who gets custody?
Depends on how long the kid's been out of the home.
Not in my court, it doesn't. And that's my point. You guys, if you're going to do this, you have to take the juvenile court hats off and put the district court hats on. I don't care about 18 out of 24 months or 22 months. I don't care about that. Don't care. I care about material and substantial change of circumstances. How are you going to prove that? I just thought about that question. How are you going to prove a material and substantial change of circumstances based on the allegations that existed at the time you got the adjudication in juvenile court? Mom was a drug user, and she was a terrible drug user, but she's killing herself to try and get better. Dad isn't around. Can you use? I just told you that the prior order is that it's what's happened from the last order to the new order. Now maybe the juvenile court filing is the change of circumstances. Maybe that is. I don't know. A lot of questions here. This was the one that, again, my wife threw the PowerPoint back at me and said, you shouldn't ask this question. But for those of you in the room, how often, and this is maybe a philosophical question because I'm certain that there are some folks, and I'm not unsympathetic to that position, but that believe that it is never in a child's best interest to be away from or not in the custody or care of a parent or another. But how often for you do you think it's in the child's best interest to not be in the care, custody, or control of either of the biological parents? Complicators. I think there's 1,000 of them. I'm just hitting on the ones that I think are the most important. And before I have my judicial brethren cranky with me, when I say inexperienced judges, I am in no way questioning capabilities of the lawyers or the judges. I'm saying, for most of you, it's been a while since you've monkeyed with domestic relations law. It's just been a while. So when I say inexperienced, I don't mean anything other than that. That's what I mean. But you're dealing in that situation with lawyers who may have some knowledge of domestic relations law or may not. And you've got judges who may or may not have a functional knowledge of the domestic relations issues. Time consumption of hearings and trials. On a standard motion day in Scottsbluff County, and I cannot believe it is any different than when I was here 18 months ago, on a standard motion day you get 15 minutes to go over a hearing. Maybe a half an hour if the judge has some extra time. And that's not a criticism of the judges, that's not a criticism of the attorneys, it's a function of volume. When you've got 400 cases to review in a year, do you have time to be monkeying around with custody trials, with discovery issues, with settings for trials? Maybe you do. This is one of my biggest questions as I looked all this stuff over. Who's writing the checks? Who's paying for all of this? For the lawyers in the room that take juvenile cases, how many of your clients are wealthy enough to hire you privately? None of them. I did this for 6 years. I did a lot of work in juvenile court. I love juvenile court. And in 6 years of practicing, I had one client who was able to pay me privately to represent them in these things. So, are we now saying that mom's attorney, who's as likely as not going to be Audrey Elliott or Pam Olson or one of the other local attorneys, Maxie Morgan, are we saying to Audrey now, well, Ms. Elliott, you've been appointed to represent Mom, and you think Mom should have custody of the kids, so now on the county's nickel, you're going to file and litigate. File and litigate. File and litigate the issue of custody. And Maxie, by the way, since you've been appointed to represent Dad, and Dad is clearly crabby about Mom trying to get custody, you get to litigate the issue of custody as well. And Mr. Pierce, I know you're not with the Scottsbluff County Attorney's Office, but for this hypothetical you are now. You get to come down and you get to represent the interests of the state, whatever they might be in that custody case. And Bernie, I've left you out. Your deputies are now coming up and they're helping Maxie, because I'm going to modify it a little bit. Maxie's just the guardian ad litem for Dad. You guys represent Dad. And Dad's in there screaming and pounding his fist on his table saying, I'll sooner croak than let her have these kids. Are we paying for all of that? I don't know. I don't know. It's a question I've got, I think is worthy of asking. Are county attorneys and public defenders to be domestic relations attorneys now too? Who's paying and who's using experts and witnesses in these things? When I have a custody trial, I want to hear from a direct witness. I don't want to hear, I mean, how much information comes into a juvenile court judge in a case plan that in any other circumstances, in any other rational set of circumstances is, I'm going to say rife, and that's understating it, rife with hearsay, rank hearsay. Hearsay upon hearsay upon hearsay. The doctor told my coworker, who told me, who told my supervisor, and my supervisor said this. And Judge Warden, you're to assume that that must be true because it's here with you in a case plan. And we accept those things in juvenile court, right? That ain't coming into any courtroom of mine. No way. So, you got witnesses. We're going to draw in the doctor who's seen the kid, the counselor, and who's paying for the counselor to come in. Are we going to have experts brought in? Because the state has oodles of money. I mean, they're just drowning in money, right? I mean, there's money coming out our ears, right? We're all, no? Is there a problem? Haven't been told. Well, all right. And here's one of the other complicators that we have not yet quite touched on. Cranky district judges not wanting their orders modified by somebody else. Now let me talk to you a little bit about that. My suggestion to all of you is if you're going to start doing these sorts of things, and I will tell you in candor that I've had one of these come up in my court. And when I say cranky, I don't mean there is clearly the authority to do it. Absolutely the authority to do it. It's an issue of respect or deference. I don't care which word you use. I think respect is the best word relative to the two types of judging that's going on there. And I submit to you that district judges are no different in that regard than a county judge. You struggle with the decisions you make because you want to make the right decision. I don't know a judge. I don't know a judge, and I've never had the misfortune, in my opinion, of ever practicing in front of a judge who didn't care. You folks who are here as lay people have no idea how well served you are by your judges. You have great judges in this district at the county court level. And me notwithstanding, I would submit to you, you have excellent judging at the district court level as well. Your county court judges, when they make a decision about placement of kids, if you don't think they sweat those decisions, if you don't think they sometimes plug their nose, close their eyes, and hope like hell they're right, you're crazy. They care about the kids they serve. And I guarantee you, I don't know a single district judge in this district that doesn't care about getting it right. Doesn't mean I'm always going to give you what you think you should get. But I sweat those decisions. You hear judges talk about the hardest decisions they have to make are sentencings. Sometimes they can be awful tricky. For me, the hardest decisions I ever make are about kids. Because I don't want to get it wrong. Because if I do, I've played a role in screwing up this kid's life, or at least helping the screwing up that's already been going on continue. So when I say cranky district court judges, let me be clear about what I mean by that. I submit to you that the district court judges who are making custodial decisions care about their orders. They have thought about them. They have struggled with them. They may have written an order that went this way, sat it down, and come back to it a couple days later and reread it and gone, nope, I'm completely wrong. I'm going another direction. And if you've invested that kind of, I'm going to say emotion, and I don't want to overstate that or misstate that. But when I say emotion, what I mean is when you care, when it matters to you that you get it right, don't you think maybe, just maybe, you might be a bit crabby when you get something handed to you that says, oh, and by the way, somebody else has taken this case and they've gone ahead and changed the decision entirely. I'm just going to throw that out there. Don't you think that that would bother you just a little bit? That's what I'm talking about. Other complicators. The Nebraska Parenting Act, I keep coming back to this. You guys have got to look at that. Because a parenting plan, if it's not a part of your order, I think the order gets kicked back. I don't even think the Court of Appeals goes any further. I think they just boot it right back and say, Judge, you completely screwed it up because there's no order. We're not even going any further on the real appellate issues here. You just didn't even put a parenting plan in there. It's coming back to fix it. Mandatory mediation, which leads to another question of who pays for it. I got folks in district court who can't pay for it. Plus, we have the issue of how many mediators do we have? Not very many. Parenting class requirement. I suspect that the parenting classes that these folks are taking for you guys might meet the criteria, but I think it's a worthy question to look at. And the last thing, child support guidelines. Judge Warden, you want to have your staff starting to worry about child support guidelines? Of course not. Of course not. And what happens is we have a district court order. I have said dad gets custody, mom pays dad $100 a month for the kids. Mom gets into juvenile court because dad's got drunk and had the kids in the back seat, and the juvenile judge says, oh, mom gets custody. But nobody bothers to tell child support. And then mom comes back a year later and says, I had a $2,500 income tax return that is supposed to be in my bank, and somebody took it. And I think it was the Department of Health and Human Services through their child support enforcement unit. And I'd sure like to have my money back. And then you come running into a district judge who says, what do you mean custody got changed in juvenile court? And we get back to complicated number 6, which is the cranky district court judge. Okay. One modest suggestion. I'm not modest about much, but this modest suggestion. In the absence of a written stipulation and agreement drafted by an experienced domestic relations attorney, don't try and change custody in county court. That is not a criticism of the judges or of the attorneys. If you guys want to get into this, that's fine. Knock yourselves out. Have a ball. But that leads to the next slide. Maybe 2 modest suggestions. Keep the district court informed in a proper and timely fashion. Here's how it worked for me in the one case that I've had this happen. Judge Rowland is my counterpart on the county court bench in my part of the state. Judge Rowland is acting in a juvenile case. There is a juvenile case pending involving 2 folks who have an open case in my court. The lawyers filed a motion in the district court to put the case on for hearing, at which time they came and said, Judge, just so you know, there is this open case in juvenile court, and one side was saying, I'd really like the juvenile judge to take up the issue of modification of custody because I think he's heard all the evidence, or there's all the evidence is down there, and rather than litigate it once in juvenile court and then come up here and do it up here, for judicial efficiency's sake, et cetera, I'd like to have it moved down. Other side objected to that. I looked at the law and thought, all right, I think they can do this if the juvenile judge is willing to accept it. So that's what I said to them. If Judge Rowland is willing to take it, you can proceed with no objection from me. But I was in the loop. And I submit to you that had I said to them at that moment, no, it stays right here, that would have been the end of the game. And it would have stayed there. Now the case is down in front of Judge Rowland, and he'll take care of it, and I have no doubt that he will, and what Judge Rowland has ordered is that whatever he does in his case gets essentially copied and filed into the district court file. But here's the dirty little secret that everybody, that nobody knows and everybody assumes. It's a common misconception, and frankly, it's a misconception that lawyers have. It's not just lay people, it's lawyers too. The assumption is that if they file it, I must know about it. Well, geez, Judge, I filed the motion to compel a week ago. Okay, I have 300 open files. You think at night before I go home, I go and, oh man, before I leave, I better check to see if Joel has filed anything new in there. No, Mr. J has filed nothing new. I guess I can go home now. The assumption is that we have operative knowledge right now of every content of every file of in every corner of the courthouse, right? Isn't quite right. And certainly I would submit to you that there are so many cases going on in juvenile court in Scottsbluff County. I mean, there's some differences, obviously, depending on the size of the court. But in Scottsbluff County, do you think for a minute that judges Warden or Mickey have firsthand operative knowledge? They're lucky if they're pulling up their file going, oh, right, okay, right. My Rolodex, I got, okay, now I got you. Okay. So give your judges a chance. That's all I'm saying. All right, maybe I'm at 3 model suggestions. When in doubt, ask somebody to help you out. My suggestion to the judges in the room is that you take a minute or two and go see your counterparts on the district court bench and say, what do you think we should do about these kind of cases? It is much better to have a process set up prior to it coming up than to have it being made up as we all go along. And so, that's it. What can I answer for you? Or try to? No questions? I've been talking for an awful long time. Yes, sir.
We do essentially what you suggest, and that is, I get these modification requests, we treat them as a separate proceeding. You have to follow the rules of procedure that apply to district court, and they settle out by stipulation. We have to attach the child court worksheet as well.
Right.
They're also not a valid order. My question is the issue of enforcement of those orders, because if people are looking for liens, they don't go to a juvenile court docket or a county court docket, they go to a district court docket. So I think it's a huge loophole in the statute. So how do you address that? Now, I'll tell you what I've done, and I don't know if it's proper, but I require the attorneys to file a certified copy of those documents in the court that originally heard the divorce.
Sure. Listen, I don't know, Judge. I don't know what the answer is. I don't know. There are, honestly, this was kind of a fascinating little venture for me. I'm glad that they asked me to do this. I'm glad you asked me to do this because, I mean, I got to be honest with you. I put my juvenile hat off a while ago, so I don't think about it like that anymore. And so for me, as I was going through this, you've heard the questions I've got. I think there's more than just one loophole. I think there are all sorts of them sitting out there that I think are questions that need answered. Whatever the answer is, I don't particularly care. I don't know whether you could somehow take a judgment from the county court, maybe have it reduced to a judgment at the county court level, and and then have some sort of procedure to transcribe the judgment into the district court file? I don't know. Maybe you have to have a hearing after you're done with it. I don't know. I would submit to you that there are going to be more cases like in re interest of Ethan M. or some amendments to the statute as these kind of questions get thrown out there. Because I don't know the answer. It's a great question, and I wish I had a better answer. I don't know what to do any differently than what you're suggesting, other than maybe have a hearing and maybe somehow that bootstraps it into, and somehow the judge can wave his magic wand and halakazam, it's now a judgment in district court. I don't know. Yes?
I have a question, and it's kind of a comment, because I hear all of the ways that there are complications and loopholes and issues, but especially given the name of this initiative, Through the Eyes of the Child, I think the reason for that law change was that if there has been a change in circumstance, that is actually one of the parents being found to be unfit, that it makes more sense for the child to live with a non-unfit parent, even if at the original time the judge decided differently, rather than have the child stay in the foster care system and forever, or sort of terminating. A lot of times the unfit parent isn't so unfit that their rights need to be terminated. So it seems from standing back and not thinking of the legal system that if there's one non-unfit parent and one unfit parent, and there's been this change that, just where the child could live and who should have primary decision-making custody and legal custody and visits, it just makes sense that there ought to be a way to make that happen.
And here's my comment to that comment. There is that way. You come to me and you file papers in the original case and you say, Judge, things have changed since the last time you heard it. My point with you, ma'am, is I don't disagree with you at all. I love I got some of the trickiest guardian ad litem cases that Judge Kammer or Judge Warden or Judge Mackey could give me. I love them. And I had kids that were out of home for years. And it killed you to see them out of home. I'm not suggesting that they should languish. What I'm saying is there was and still is a procedure that exists to account for them.
But I thought that one of the motivations was that in some courts, a district court judge, that wasn't happening. That either the district court judges were reluctant to. I don't remember exactly, but there wasn't a smooth flow. That one of the courts was saying we've got to wait for this other thing to play out.
And that may be. That may be. I don't want you to get the wrong impression. I'm not here to say to junk the law, and I'm not saying it doesn't have utility. I'm saying that there are things that you have to flesh out to make it, if what your goal is, and I think it's a good one, to more efficiently deal with these kids. I submit to you that this law may be a decent first step in that regard, but you aren't anywhere close to finishing the project, in my opinion. Because I again get back to, you've got questions about funding, you've got questions about propriety of parties that have no particular say in a district court proceeding, having, I think, tremendous authority in a juvenile court proceeding. And I'm specifically commenting on the state of Nebraska. And what worries me the most is that you're going to have lawyers, public defenders lawyers that are specialists in criminal law and do juvenile work trying to be divorce lawyers. And that, I don't want you to misunderstand me. I'm not suggesting
no,
it's...
I guess I'm wondering whether there's, I'm just trying to see if there's a solution. I had nothing to do with
Sure.
the original law, but I do think that there is a need for more efficiency for, if there is a fit parent,
Sure.
To have children be able to live with a fifth parent rather than being in the foster care system seems like a laudable goal. And I guess I would encourage the district court judges and the juvenile court and county court judges to maybe try and put some more details into the law or whatever that might make it work better.
Sure.
I know a huge roadblock too is usually the parents don't have the money
Sure.
to get the attorneys to get it into district court. I know we've seen cases stay open because the parent can't afford to get it to district court.
Well, and all I would say to that is come down and see me on motion day in any of the 5 counties I've got. And I would submit to you, I don't have the exact numbers in front of me, but I would submit to you that at least 30%, if not closer to half, are coming to me completely pro se or at least partially pro se. They're just coming in and they're filing pleadings in the district court that are handwritten. And I'll accept those. I mean, I think I have to, because they're pleadings. I get letters from somebody and I'll read them as pleadings, because I can't respond to letters, but I can respond to a pleading. So I understand your point, and I think you're absolutely right. That's exactly right. Folks in juvenile court don't have the money to hire lawyers, and I'm telling you, there's a whole new, Judge Castle, I think, is the guy that's running the shop on the, or is in charge of at the appellate court level on the pro se and indigent litigant issues. There are forms now that are available from the website. I've instructed my clerks, the clerks that are in my courts, to if people come and say they don't have an internet connection, to point them to the local library and give them the website. So I understand your point, and it's well taken, but I submit to you that the days of waiting for an attorney to take your case up to a district court are long past. What else? Yeah.
Maybe you want to jump
No
back.
comments on pending cases, Jay. I don't want to hear any of it. Okay, I'm sorry.
All right, then never mind. Maybe you want to jump back to the earlier comment and just to deal with the timing issue. Maybe comment on the practical aspect of district court made an order, maybe even a temporary order, but then juvenile court jumped in, and so we have maybe a different placement, as district court said, and it just hangs out there. Some thoughts about eventually juvenile court wants to close it. We might have resolved everything, but as soon as they do that, then it bounces back, and
I think
the kids move back immediately or not. Or
I think that did all of you hear that question? Okay, the question was, and he referenced a temporary order, and I won't go into that with you.
or even
too
a
much.
permanent
Right.
order or whatever.
The issue being that there's this prior order from the district court and something changes where the juvenile court comes in, and maybe the juvenile court order changes the arrangements that were in the district court order. When a juvenile judge closes a file, that's it. I mean, whatever the order was, it's done that day. So his question is, if the district court order, if my order says dad has custody and the kids live with dad, and the juvenile court case and the juvenile order says kid lives with mom because dad's fallen apart, and mom has the kid in her home for a year and a half until the case closes, at the minute that case closes, the nanosecond the ink dries on Judge Warden's order closing the file, my order is the order in place. So the question is, does that mean son goes back to dad that day? And I think the answer is yes. Which I submit puts it on the lawyers, and maybe this is, I don't know, this is maybe one of those things that the lawyers who are doing juvenile work are going to have to say to their clients. Just so we all know, once Judge Gendler signs the order closing the case, whatever the prior order is, and I can't take you upstairs and work through the district court case for you, but you need to do something with it. I don't know. My answer to you, Joel, would be that I think what has to happen, I think that gets back to Judge Warden and Judge Mickey going up and having a conversation with Judges Dubrovoni and Lipstrew to say, how do you guys want to handle these kind of cases? Because all this discussion aside, these things don't happen all the time. I mean, these aren't happening 56 times a day. But you don't want to be guessing about what should happen when they do come up, because you're dealing with a kid. And the kid doesn't care. The kid wants stability. The kid wants to know where he's going tonight. That's what he wants to know. I've been all right with Mom. Why are you stinking judge sending me back to Dad? You dingbat. I've been all right over. Okay, well, if I don't know, and that gets back to, if I don't know about it, how can I change my own order? I can't change my own order unless somebody brings it to me. I don't have authority to just unilaterally go in and say, you know what, I signed that order on Friday and I changed my mind on Monday. I'm going to just go in and change it. I don't have that authority. The only way I can modify it is if you come back to me. So I think the answer, at least in part, Joel, is that Judge Rowland and I have to sit down and we have to figure out what our plan is going to be. And we need to tell lawyers like you that do this sort of work and say, okay, because you're going to plan for that.
I think that it could be practical to have the juvenile court order the day of the hearing in district court.
Right.
Something like that.
That's right. I mean,
But then you're going to count on everybody.
there's a lot of intelligence in this room, and there's a lot of intelligence at the bar level, at the bench level, and at the layperson level. These are not problems that are insurmountable, but they are problems. They are issues. What do you call them? What's the vernacular now? Roadblocks, right? They're roadblocks. All we have to do is move the roadblocks. Okay, well, we'll move the roadblocks. Here are the roadblocks. But I think you're right. I think that's part of it. I think that's a solution to it. But I think ultimately it's going to be Judges Harford and Plans talking with Judge Silverman and saying, what do you want us to do? Oh. What else? One more. Yeah.
What is the procedure, for example, if you have one parent who has counsel, one parent who does not, and you also have a counselor, per se, a therapist who's been working with the parent without a lawyer, who wants to get their opinion of concerns about separation questions, that kind of stuff.
In a district court proceeding,
In a custody district.
it's up to the pro se litigant to be able to present that evidence in a proper and evidentially correct fashion.
Which is.
Not my job to tell them.
Well, I know, but that's, as being someone who
No,
works with families,
the answer is they have to be. You can appear pro se, but you're held to the same standard as a lawyer would be held to. So it's the rules of evidence regarding presentation of expert opinion, which I would tell you trips up lawyers all the time. So I'm not trying to be difficult with you. I understand your question, and my answer is we don't have time for me to go over everything that they're going to have to do to get an expert's opinion in front of the court. First of all, the counselor has to be there. It isn't going to be enough, which is always what happens with a pro se litigant. Well, Judge, here's the thing. I have 14 people that wanted to testify for me today, but they couldn't be here, so here's 14 letters. They all signed it. See, right here. They signed it right here. This is their signature. That's it, right? It's right here. So I want you to think about that. Absolutely not. No way. Complete hearsay. Total hearsay. And always full of opinions like, Dad's a dirtbag loser who shouldn't be anywhere within 14 feet of a kid, much less this kid who, he's done everything but whatever for the last 10 years. She's clearly the best mom ever. Greatest mom since sliced bread, whatever. They're rank hearsay. Opinions that are completely irrelevant and wouldn't come in if they were sitting here. But they never show up with their witnesses. Ever.
well, in my case, I know that someone was going to go.
Sure.
Yeah.
Well, they can. But they should come expecting that the judge is going to look at them and say, you can call whatever witnesses you want. But when the objection comes from Mr. McDonald on behalf of his client that you're not properly qualifying this person as an expert witness, which takes some doing, then they can't be surprised, shocked, or otherwise put out when the judge looks at them and says, objection is sustained.
Is an expert witness considered a licensed therapist?
An expert can be, well,
I'm not a lawyer.
no. There are procedures to go by to qualify someone as an expert. It can be based on credentials like I've got a PhD from Harvard and my engineering degree from MIT. It could also be I'm here as an expert mechanic and my expertise comes from 30 years of tearing apart diesel engines. So I know diesel engines better than the dingbat engineer you brought in from the University of Nebraska, because I've gotten my hands dirty every day for 30 years doing it. That person is just as much of an expert as the mechanical engineer. So I don't know that answers your question, but that's the best answer you're going to get from me.
Okay, thank you.
What else? Hang on, yeah.
Judge Weimer, since I've known
You can call me Derek, it's fine, I don't worry about it. I don't stand on ceremony.
Okay. My question is how much input, if it's age appropriate, does the child have in the court as far as being able to
Sure.
say who, which?
It's a great question, and the answer is some, and it depends a bit. It's a determination made by the judge. A 6-year-old, I'm not going to probably hear much from, because a 6-year-old, I mean, I got a real smart 6-year-old at home, much smarter than me. But if I told her today that the moon was made of green cheese, she'd tell everybody in the world the moon was made of green cheese because her daddy said it must be so, so it must be so. Now you talk to my 9-year-old who's going on 30 and who is even more smart than her other sister and therefore much more smarter than me, who could work the PowerPoint better than I can, which really drives me crazy, to be honest with you. But she would be able to come in and she would articulate, for example, she asked for a cell phone. And when I said no, she said, "But Dad, we don't have a phone at home. In the event that I were staying home by myself. And I needed you, Dad. I need you." Big, doughy, blue eyes, and she's very good. I haven't got her a cell phone, but I was thinking about it. Right? She had me at least roll in that direction, right? Okay, my point is, it's not a bright line. At 12, they get to testify. It used to be. It isn't that anymore. It is, the case law has changed on that and has said the judge hearing the evidence has to make a determination of essentially, is the kid being manipulated? Can the kid testify in a fashion that suggests that they are really telling me their actual opinion, or are they cribbing notes from mom or dad or whoever? So I've allowed testimony from kids as young as 8, and I've disallowed testimony from 14-year-olds. Because you listen to some of the things that the 14-year-old is saying, and they're using words that no 14-year-old in their right mind. Well, there's been a material and substantial change of circumstances, Your Honor, and it's clear because the material and substantial change of circumstances is my mom sucks. Well, who told you that? Well, you know, Dad kind of said something about that. But none that he was trying to manipulate me at all. I mean, no. Okay, you go. Sorry. I'm sorry, I'm wandering off.
Fine.
So,
Thank you very much.
Yeah.
You know, we have judicial branch education in the state, and I think we just got one new good speaker.